It will not lacerate, dissolve, it will lobster and prog, etc., etc. We're not concerned with that.
Think flow is an expression of a court, not an expression of
That's my case.
even interpret it on the basis
No,
of
I
either
am saying-
Banduri or.
My learned friend's entire argument is based on those 4 lines. Well, that's my argument. Great respect.
Taking two extremes.
Very well. Now, I leave that and come to
Think flow is an expression of a
just
court.
ending this part at page 61. Just 2 lines.
Even interpret it on
There is
the basis of
obviously no
either
fifth
Banduri
option,
or,
which my learned friend, that's my para 39. Page 61, para 39. I have given 6, 7 reasons for this following through point. I've left it nominous. I'm on page 61, para 39. No fifth option. Obviously, I'm saying there's no fourth option also. Leave aside the fifth option.
There is obviously no.
And the only option clearly given by the constitutional discretion, undoubtedly so, is the second proviso. I end on that verse. I've given 6, 7 reasons for this following through point. I've left it nominous. Whereas there is a small conclusion I put at page 61, no fifth option. Obviously, I'm saying there's no fourth option also. Spend time, leave aside the fifth option. It's the two swords and in the one only scabbard option argument clearly I made given by earlier. the constitutional
You already made it.
undoubtedly so is the second proviso. Leave that end on that verse. I've given 6, 7 reasons for this following through point. I've left it nominous. Whereas there is a small conclusion I put at page 69. I'm dealing compositely with 4 issues. I'm saying there's no fourth option also. Spend time, leave aside. Judicial review. Your lordship's doing judicial review means judicial supremacy.
Justiciability.
Well, questions are 3, 4, 6 and 9. Open the questions. 3, 4, 6 and 9. It starts at page 63 of my note.
3, 4.
3, 4, 6
and
and
9.
9. Compositely, they are well, judicial review. My lords become supreme because my lord does judicial review, justiciability. All are these 4 issues. My lord can glance at the issues again. 3 is the exercise of 200 justiciable. 4 is also included. 361 is a bar to your lordship's judicial review. That's a question 4.
You have mentioned that.
Yes. So I'm just saying, Malas, they are the questions. Then, Malas, 6 is the exercise of 201 justiciable. Similar, overlapping. And then last and interestingly, 9 are the decision of the governor and the president under 200 and 201 justiciable at a stage anterior to the law coming into force. Is it permissible for the courts to undertake judicial adjudication over the contents of the bill in any manner before it becomes law? And in the submission, Mr. Mehta, he also used the word judicial supremacy, otherwise will be inaugurated, etc. So I'm dealing all compositely. As usual, Malas, I've made 6 or 7 point summary, then the quotations will come. So just read the summary, that's important. That summarizes the whole case in 2 pages. At page 63, para 47. This is the summary of the entire case on judicial review. Page 63, para 47. In respect of articles 200/201, neither the governor nor the president involved.
Para.
47, Malas,
What is it?
at page 63, small page. Big page is 542. May I read, Malas?
Yes.
Some of these are answering, Malas, Mr. Mehta's submission. Now, he used the word high prerogative. It's not my word. In respect of so-and-so, neither the governor nor the president enjoy any general high prerogative or plenary power which is immune from judicial review or justiciability. Why? In a constitutional republic governed by rule of law, judicial review and the supremacy of the constitution, not the judiciary, the very concept propounded by the government in this regard is fundamentally erroneous. This is expanded in paras 55 to 64. Judicial review has been repeatedly held to be part of the basic structure of the Constitution, is exercised in diverse and multifarious situations, ouster clauses of different sizes and colors, no-go areas of different use, statutory and constitutional bars of differing width and amplitude have repeatedly been rejected by constitutional courts as a legitimate ouster of judicial review. Many diverse examples my lord has. In every area. Where he has discretion. Here, in most cases, he has no discretion, but where he has discretion, judicial review never ousted, or even was in any manner controlled. Basic structure. That's 65 to 78. Actions in violation of explicit constitutional text or in breach of clear constitutional intent of the founders or at variance with the context of a constitutional provision or its rationale cannot be immunized from judicial review by recourse to the doctrine of political questions, which is wholly, my learned friend uses the phrase, this is not my word again, high prerogative and political question in Mr. Mehta's phrase, which I'm answering in para 79 to 85. Withholding of assent and thereby supposedly making the bill fall through has no connection with and is wholly unrelated to the alleged bar of quia timid actions wrongfully applied through the fallacious invocation of Kyoto. One argument, my learned friend, is that Kyoto prevents quia timid injunctions. And a falling through means that your lordship will be interfering at the interim stage, and that is barred by Kyoto. With greatest humility, it's the most convoluted argument. It has no application to the case, none. 51. Protective provisions providing an arc of protection for several diverse public servants, even in ordinary statutes, forget 361. And similarly to high personages like the President and the Governor in articles like 361, in respect of any act done or purporting to be done by them in the exercise of their powers and duties, have never been interpreted or applied to oust judicial review and justify arguments of lack of justiciability qua the actions and decisions of such persons. They are a well-established old paradigm for provision of a protective umbrella against personal, civil and criminal actions in respect of work done by holding their office. So, if I take a decision, your lordship quashes the decision right, left and center. But that doesn't mean that your lordship quashes, then I file a second action for tortious liability against the governor. 361 is that. And it's a well-known common law exception from 300 years in England, which has become 361. Judicial review, again, nothing to do with judicial review. Because judicial review hits the decision of the action. 361 bars the personal immunity from civil, tort, contract. It will be totally irrelevant to the case. I'll cite the cases coming in there. Yes. The provision in US is on 361 is much narrower, but barring the last step has been interpreted by US Supreme Court to mean the US President can grant pardons to anyone, and now supposedly to himself also. Now supposedly to himself also. That last part is not decided, but it is likely that it is so going to be held. Anyway, let's go on. The fundamental fallacy of the Union of India's averments on the alleged non-justiciability of a governor's president's actions under 200-201 is that they proceed on the flawed assumption that the governor exercises high prerogative and plenary power. This is Mr. Mehta's submission in 281. Wrong. Completely decided cases say it is wrong. And then discretionary powers I've already said. Now let's go to 47. The first para was 47. I'm elaborating it from 55. Neither the governor nor the president enjoy any high prerogative or plenary power, immune. Well, this is found in para 55 of my note at page 281 of his submissions. Ignore it. Let's just note the reference. Ignore 56 also. Come to 57. Well, this is a slightly different but related topic I'm getting out of the way in the beginning. This is not that. Here I'm showing that governor exercises no legislative powers. It's well decided. He is part of a legislative process. He exercises no legislative powers. That's a very important distinction. The impression given to your lordship is because he is part of a legislative process, therefore he is also exercising some legislative powers.
The condition is not that. The condition is that he is also a part of the legislature. The legislature consists. No, that's their argument.
Correct.
That in a bicameral house, the legislature consists of the two houses and the governor, and an unilateral.
Absolutely.
The legislative assembly and the governor.
To the extent that obviously when he receives a bill, gives an assent, before which it doesn't become an act, he's part of a legislative process. Therefore, the legislature consists of one house plus second house plus governor's assent. To that extent, I have no problem. But to add to that he exercises indirectly by virtue of the first point, any legislative function or power is constitutionally fallacious. That's what I'm showing. It's a nuance, very clear nuance. Navam Rebia decided it beyond doubt.
According to you, his powers are restricted by whatever is specified in 201.
200 and 201. That's the answer. So, Malas, you had to put 200 because there is one house.
Whatever options are available to him under 200.
Or 201 is the case.
How about 201?
He is the Malas mover of the bill. The mover of the bill comes to the assembly. One house. Goes to the upper house where it exists. Goes to the governor. No, nothing becomes law till the 3 steps are over. He's part of the legislature in that sense. That does not mean that he can either kill a bill. He can decide that the bill is a threat to national security, to foreign policy, to economic policy of India. That there is any extra power than what 200 gives. That's all I'm saying. Now, Navam Rebia clarified this. Come to Navam Rebia in para 57 of my submissions. Constitution bench, as your lordship knows. Well, there may be a typo there. That para is 147.2.
It's correct.
It's correct, I think, in your lordship.
147.2.
Even though Article 168 postulates the legislature of a state would comprise of the governor, yet the governor is not assigned any legislative responsibility in any house of the state legislature. The only function vested with the governor is expressed through 200. This is what my Lord the Chief Justice observed just now, which inter alia provides that a bill passed by the state legislature is to be presented to the governor for his assent. And its ancillary provision, namely 201, wherein a bill passed by the state legislature and presented to the governor may be reserved by the governor for consideration by the president. The only exception to the non-participation of the governor in legislative functions is the ordinance making power. 213. The governor under 213 can promulgate ordinances during the period when the House is not in session. This function is exercised by the governor undisputedly on the aid and advice of the council with the chief minister as the head. Then Mark Justice Kehari uses this phrase again and again, Manus. All in all, it is apparent that the governor is not assigned any significant role even in the legislative functioning. Then 148. The above position leaves no room for doubt that the governor cannot be seen to have such powers and functions as will assign to him a dominating position over the state executive and the state legislature. This your lordship saw earlier. See the bottom of that page. According to the respondents, it makes the governor's orders based on his own discretion immune from judicial review. Same argument. Accepting the above position will convert the governor into an all-pervading super-constitutional authority, what I call a super CM or a super legislature. This position is not acceptable because an examination of the executive and legislative function of the governor from the surrounding provision of the Constitution clearly brings out that the governor has not been assigned any significant role either in the executive, which we are arguing, or the legislative functioning of the state. Then, Wallace, this is the question which came last time also. It's directly answered by me orally. Now I'm put in writing here, Wallace, in this para. That is para 58. In para 286 of its submissions, and I have serious objection to many of these paras because they turn the constitutional scheme on its head completely. 286, for example, says that the governor has decision-making functions and has to consider questions of repugnancy or violation of constitutional fundamental rights is ex facie erroneous. Stated briefly, the tests of constitutional vices, repugnancy, are to be tested by the judiciary under Articles 32 or 226 under judicial review. The governor does not possess any powers to conduct such an examination of the bills duly passed by the assembly, save and except as per the second alternative argument that he can either send the bill back or refer it to the president. That's a different matter. You can't judge it. You can't judge it. He cannot conduct a de facto judicial examination or adjudication and hold back assent indefinitely on his own perceived view about the alleged unconstitutionality of any bill. Then let us come to 66. The suggestion is
66.
Yes, 65 is a repetition. Navam Rebia is again the same thing. 66 now. Oh, I'm sorry. No, my apologies. Sorry. 60. My mistake. My mistake. I read 59. 60. It is equally wrong to suggest that because the inaction of a governor or exercise of non-existent power under 200 would be subject to judicial review, even grant of assent by the governor, one argument made is that if you are doing judicial review of withholding and all this, then even the assent can be subject to judicial review. and that too by a private party. Specific argument in para 290 of the SG's submission. Now my answer to that. A private party can challenge a statute only on the constitutional values of a statute or a lack of competence in its passage. The challenge would not be based on allegations requiring examination of the assent granted by the governor. But these are all created controversies with greatest respect. They are very well established for 75 years of our republic. In other words, any bill is challengeable by any such private party only when it becomes an act of parliament or state legislature. Because I come to your lordships many times before the act, your lordship says a bill, go back. Happens all the time. After this happens, the challenge is on the usual constitutional grounds, ranging from alleged lack of legislative competence to a whole range of constitutional invalidity, allegedly arising from diverse provisions like 14, 19, 21, 300A. These are what we do before my lords. None of this involves or can involve a challenge to the governor's or president's decision to grant assent. It has never happened. In none of such situations is it necessary or conceivable the private party will challenge or needs to challenge the factum of assent or why the governor president gave assent. This is a completely erroneous argument. Such issues are completely alien and irrelevant and have been erroneously conflated in the written submissions. Equally fallacious is the return to prerogative power. Prerogative power is mentioned in 280-81 of his submissions. This is again Malus conflating it with the royalty. Your lordship has said, in a republic like India, there is no such thing. We are a republic governed by the constitution. A republican constitutional system with a dynamic written constitution is antithetical to any concept of prerogative powers in any authority unless, in the rarest of rare cases, a specific constitutional provision consciously and specially chooses to invest that authority. That's not prerogative, that's constitutional power.
Like 356.
Like 356, exactly. And other matters. The decision of this, and Maras, the interesting thing I'm coming in this, 356 clearly gives you discretion. So does 362 and those Maras provisions of pardon. 200 is where you have no discretion. Even in 356.
You have a discretion, you can make choices between what option given under 200. Either to withhold or to give assent or to reserve it for the.
It's a constitutionally given option. Discretion within each option is not available. Now, in the articles where discretion is available, 356, 362, 372, 371, even there your lordship has done full judicial review. My learned friend is saying there is no judicial review where discretion is absent. In articles with wide discretionary zones, my lord has done vigorous, full, comprehensive judicial review. That's the story your lordship is coming to now in a minute. But first see this prerogative. This is only on the prerogative. The next question is whether this court should adopt the rule of construction accepted by the Privy Council. This is 67 judgment. There are many reasons why the said rule of construction is inconsistent and incongruous in the present setup. We have no crown. The archaic rule based on the prerogative and perfection of the crown has no relevance to democratic republic. It is inconsistent with the rule of law based on the doctrine of equality. It introduces conflicts and discrimination. And my learned friend raises it directly in 280-81 of his submissions. Then come to the next page. Are you sure? Just check it.
Yes,
Well, I forgot to write there. I'm told this is 9 judges. Just check it. It's my fault.
Which one?
This fellow superintendent remembrance.
Corporation of Calcutta.
9 judges. I should have written it there, but kindly write it there. That combination is rare now. Sign 367. 67. Now let's come to the next page. 24. Page 69, small page, para 24. There is therefore no justification for this court to accept the English canon of construction, for it brings about diverse results and conflicting decisions. On the other hand, the normal construction, namely the General Act, applies to citizens as well as state, unless it expressly or by necessary implication exempts the state from its operations, steers clear of all anomalies. It prima facie applies to all states and subjects, a construction consistent with the philosophy of equality. In our constitution, this natural approach avoids the archaic rule and moves with the modern trends. This will not cause any hardship to the state. The state can make an act if it chooses, providing for its exemption from its operation. Last sentence is important, Manas. Because prerogative was used to exempt yourself. Now this statute will exempt it if you want to. Next page, 70. We therefore hold that the said canon of construction was not the law enforced in the meaning of 372. In any event having regard to the foregoing reasons, the said canon of construction should not be applied for construing statutes in India, namely Malas exemptions drawn from the prerogative power. That was the issue in that case. Followed Malas in Ravi Chandra. Tell me the number of judges, write it down.
This was by how many judges?
Yes.
Ravi Chandra was how many judges?
Division bench. Ravi Chandra is division bench. And it specifically follows Malas, this 9-judge bench. Just see the boldface. Governments taking a cue from the English experience initially asserted they are not subject to the law, insisting upon the continuation of the royal prerogative by virtue of Article 372, which enabled the Crown in the UK to assert its right to insist that it was not bound by the law unless there was express statutory intent. Mercifully, a later judgment overruled that understanding. Very pithily put, Malas. Then, Malas, they have quoted mercifully that judgment on the next page. I'll not read it, the same judgment. Come to the lower part, Malas, para 65. Now, in 65 onwards, I'm elaborating 42 and 52, where the proposition was judicial review has been repeatedly held to be part of the basic structure. Because these 4 issues of judicial review, your lordship has gone very far. While an friend is talking of non-discretionary power not being amenable to judicial review. I'm going to show lordship other extreme of reality. It is not in any manner, so it is part repeatedly of the basic structure. It is not in any manner synonymous with or intended to result in the supremacy of the judiciary. That's a very erroneous submission. Judicial review has been repeatedly held to be part of the basic structure in multifarious situations. And the best is, when the lordship has tried to oust or attenuate judicial review in different hues and colors, in different situations. My lords have had those experiences. And what have my lord said? 66. Judicial review is not in any manner synonymous with or intended to result in the supremacy. The judiciary, Malas, is the designated organ as the interpreter of the constitution. And the job is to ensure the supremacy of the constitution through judicial review. Your lordship is the designated organ. Your lordship can't help it. You have no option. If you are the designated organ to decide the supremacy, not of the judiciary, but of the constitution, then you are doing that job and not making the judiciary supremacy supreme. Now, Malas, this is the approach when a lordship tries to even attenuate judicial review. This judgment is 7 judges, para 68. My lord may not find that, because it was added later on by me. 7 judges. That is, Malas, powers, privileges, immunities of state legislatures at para 68. This is 7 judges. And Malas, Chief Justice Gajendra Katkar says, the supremacy of the constitution is the correct phrase, not the supremacy of the judiciary. The fact that you are the interpreter does make you supreme. That's a different matter. This supremacy of the constitution is protected by the authority of an independent judicial body to act as an interpreter of a scheme of distribution of powers. Then, Malas, state of Rajasthan was a letter saying the state government should go. 7 judges in state of Rajasthan. And these are all examples where discretion is available. Discretion is given. And yet look at the judicial review. 150, page 73, larger page 552. But one thing is certain, that if the satisfaction is mala fide or is based on wholly extraneous and irrelevant grounds, the court would have jurisdiction to examine it, because in that case, there would be no satisfaction of the precedent in regard to the matter which is required to be satisfied. The satisfaction of the precedent is a condition precedent of the exercise of power under 356. Of course, by reason of clause 5, look at this for us. The satisfaction of the precedent is final and conclusive and cannot be assailed on any ground. But this immunity from attack cannot apply where the challenge is not that the satisfaction is improper or unjustified, but that there is no satisfaction at all. In such a case, it is not the satisfaction arrived by the precedent which is challenged, but the existence of the satisfaction itself. End of that page. Where it is possible, the existence of satisfaction has always been challenged on the ground, not mala fide alone, based on extraneous and irrelevant grounds. Enough techniques and tricks have been tried. Your lordship has found enough language to get around it. Now see this Bomai. Now the first one is 9 judges, of course. First, this what I'm reading, para 96, is by Justice Sawant and Kuldeep Singh. Justice Kuldeep Singh. The Constitution is essentially a political document, and provisions such as 356 have a potentiality to unsettle and subvert the entire constitutional scheme. I'm just reading only the boldface. It's
Yes.
enough. Don't just think that I'm avoiding anything. It's just that it's enough, I think. Democracy and federalism are the essential features of our constitution and are part of its basic structure. Any interpretation that we place on 356 must therefore help to preserve and not subvert that fabric. Now, next page is important. Page 75. So long as the states are not mere administrative units, but in their own right constitutional potentiates with the same paraphernalia as the union and with independent legislature and the executive constituted by the same process as the union, whatever the bias in favor of the center, it cannot be argued that merely because, and assuming it is correct, this is the direct point for us, the constitution is labeled unitary or quasi-federal or mixture of federal and unitary, the president has unrestricted power of issuing a proclamation under 356. Then this 255 para is by Justice Ramaswamy. Some of these things are missing in your submissions for us. Judicial review is a basic feature of the Constitution. This court, high courts have constitutional duty and responsibility to exercise judicial review as the sentinel on the qui-vive. Next page. However, justiciability of the decision taken by the president is one of exercise of the power by the court, hedged by self-imposed judicial restraint. It is a cardinal principle of our constitution that no one, however lofty, can claim to be the sole judge of the power given in the constitution. This court, as the final arbiter in interpreting the constitution, declares what the law is. Higher judiciary has been assigned a delicate task to determine what powers the constitution has conferred on each branch of the government and whether the action of that branch transgress. It is the duty and responsibility of this court and the high courts to lay down the law. That's why lordship is called supreme, and that is the supremacy of the constitution you are upholding. It is a constitutional duty to uphold the constitutional values and to enforce the constitutional limitations. The judicial review therefore extends to examine the constitutionality of the proclamation issued under 356. And we are dealing fully with justiciability. When your lordship finds that your lordship is doing in the act of doing judicial review, some question I ask is not capable of, your lordship, same phrase, really different species, judicially manageable standards, your lordships cannot go into. Your lordship takes your hands away. Justiciability is not a legal concept with a fixed content, nor is it susceptible of scientific verification. Its use is the result of many pressures of variegated reasons. Justiciability will be looked at from the point of view of common sense limitation. Judicial review may be avoided on questions of purely political nature. Though pure legal questions camouflaged by political questions are always justiciable, the courts must have judicially manageable standards to decide a particular controversy. The next 4 lines may also be underlined. I have not underlined it. Justiciability on a subjective satisfaction conferred in the widest terms to the political coordinate executive branch created by the constitutional scheme itself is one of the considerations to be kept in view in exercising judicial review. There is, of course, the initial presumption. Then, 372 is Justice Jeevan Reddy's author, Justice Agarwal with him. Justice.
So next line would also be relevant.
There is an initial presumption the acts have, I said so, initial presumption that the acts are regularly performed. Always. You start with the initial.
You start with the presumption.
You always start.
And then
you can't straight away say that this is on the face of the
person who challenges that.
Absolutely.
To rebut it.
There's no problem.
And unless there is a strong material, the court will always presume in favor of.
The challenger has to overcome the presumption. After he has broadly overcome it in the prima facie stage, it shifts to him. Your lordship asks him the questions. It shifts back to me, Malad, in case I am not able to answer the question. Absolutely. Your lordship does it every day. Now, Malad, this is Justice Jeevan Reddy and Justice Agarwal, starting from 372. Come to the next page, para 373. I have quoted more because I want to not suggest that I am not quoting the entire thing. Para 373. Whenever a proclamation under 356 is questioned, the court will no doubt start with the presumption that it was validly issued, but it will not, this is my Lord Chief Justice's query just now, it should not hesitate to interfere if the invalidity or unconstitutionality of the proclamation is clearly made out. It should not hesitate to interfere. Refusal to interfere in such a case, very strong words, Manus, would amount to abdication of the duty cast upon the Supreme Court and the High Court by the Constitution. Then, Malus, the judges give Malus the grounds. They cite a lot of case law, Malus. And your lordship knows otherwise. I have quoted 3 sets of judges, Balas, in Bombay. I've quoted 3 sets of different judges, Balas. There are many more paras. This is not intended to be exhaustive. It's a very long judgment. Balas. Now I come to, can't have this keep changing constantly. Then Balas 71 para. This is Balas judicially manageable standards. Now Balas, I'm asking myself a simple question, common sensical. My lord finds page 80, small page 80, small page 80, para 71. Now, your lordship, I'm sorry. Well, this is judicially manageable standards, one part of it. You forget, well, for a case for 30 seconds. Your lordship, let us say, finds that the governor is wrong in exercising a withholding assent or indefinitely for 1400 days, 2000 days, keeping back a bill. Suppose your lordship so finds. What is the unmanageable judicial standard? And this is what I ask myself. If my lord does not give the full remedy till the last, then it's only a formality. It's only a superficial adjudication. What is so impossible of judicial management? Your lordship manages much more in judicial management and judicial review, much more. Here you have the text of the constitution to guide you. So judicial manageable, I am only answering because my learned friend raised it. I think it doesn't arise at all. I'm only answering because he raised it. AK call Malats. Just come to the bottom of page 80. Since the task of interpreting the provision of the Constitution entrusted to judiciary, it is vested with the power to test the validity of an action of every authority functioning under the Constitution on the touchstone of the Constitution in order to ensure that the authority exercising the power does not transgress the limitation by the Constitution on exercise of that power. This power of judicial review is therefore implicit in a written Constitution unless expressly excluded by a provision of the Constitution. So it's the other way around. Unless expressly excluded by a provision of the Constitution, the power of judicial review is available.
No. Such exclusion is also held to be
Correct.
violating the basic
No,
structure of-
my lord attenuates it. For example, atomic energy plant. My lord sometimes in a statute, it happens in a statute, attenuates it. That no natural justice is required, no hearing because it's a atomic energy, some sensitive war plant. I mean, those are very rare cases in a war or in some military installation. Nobody is arguing that kind of case. You are arguing that these are all answers to arguments. There are 4 arguments. Judicial review is minimal. It is not justiciable. There are no judicially manageable standards. It is a political question. It's a high prerogative power. All this is set for 200 and 201, Malas. What is the texture and the textual feel of 200, 201 if your lordship has a thicket of these objections, one after the other? The only intention is don't go to the real issue. Justiciably relates to a particular field falling within the purview. So, Malas, your lordship is right. In a particular judicial review, you have, but you will not do it in an atomic energy, national security, war situation. That's obvious. It's common sense, Malas. It's a common sense. And I don't think the courts have 99% messed up on that account. The courts are wise enough to know the field. We know the difference immediately. Where your lordship is a no-go area and where there is no problem. It's a self-imposed limitation. It's completely self-imposed. There are 1 or 2 aberrations. My lord always finds. That doesn't make the rule, Malas. My lord knows of the aberration of a platform in my lord's home state in Allahabad, where a judicial order
Don't
was
cite
passed.
individual cases, otherwise he is going to start from 1952.
On account of want of judicially manageable standards, there may be matters which are not susceptible to the judicial process. That's the lordship's own, what is known as nuancing. Then, just I'm not reading it. Para 72 of mine quotes mentions Rameshwar, which fully endorsed Bommai. That's another 5-judge bench, endorsing a 7-judge bench with those on that point. Now, there is a little overlap. I must read the next page of Rameshwar, which deals with personal immunity. But note that 361 is not this subject here. But Rameshwar comes here, it deals with 361, but I'm not dealing with 361 yet. It's coming later. But I'll read Rameshwar, it's important on judicial review. 361 is coming shortly, though Rameshwar here also deals with 361. We are unable to accept the contention urged by learned Attorney General, Solicitor General, Additional Solicitor General appearing for the government that the report of the governor itself is the material and that it is not permissible within the scope of judicial review to go into the material on which the report of the governor may be based and the question whether the same was duly verified by the governor or not. This court cannot remain a silent spectator watching the subversion of the constitution. It is remembered that this court is the sentinel on the qui vive. This is what the Bomai said. Next page. Page 83, para 173. A plain reading of the aforesaid article shows, after that the boldface. The boldface. They give an example in judicial review. The personal immunity from answerability provided in 361 does not bar the challenge that may be made to their actions. It's very simple. Under law, such actions, including those actions where the challenge may be based on the allegations of malafide, are required to be defended by the Union of India or the state as the case may be. I'll come to that in a minute. Even in cases where personal malafides are alleged and established, it would not be open to the governments to urge that the same cannot be satisfactorily answered because of the immunity granted. In such an eventuality, it is for the respondent defending the action to satisfy the court either on the basis of the material on record or even filing the affidavit of the person against whom such allegation is made. 361 does not bar filing of an affidavit if one wants to file on his own, and that's done in many cases. The bar is only against the power of the court to issue notice of making the president or the governor answerable. In view of the bar, the court cannot issue direction to the president filing, etc. Just pause here for one conceptual diversion for 30 seconds. In one sentence, it completely harmonizes. X, the president or the governor, takes a decision Y. Number one, the decision Y can be challenged on all available judicial review grounds. I don't have to recount them. Number two, that challenge includes a malafide challenge to the decision. Number three, neither of these challenges by me to legislative competence, decision, vires 1914 allows me to personally sue the president or the governor. Give me damages because you made a wrong decision. Give me penal damages because you made a wrong decision. Number four, even in malafides of that decision, the government of the day, the secretary, files an affidavit. It doesn't mean that because the governor is immunized from filing for his personal immunity, that malafide decision will go unchecked, unsupervised. So what's the disharmony? The disharmony is what you deliberately have created because you want to avoid scrutiny. It's as simple as that. Now come to Epuru, next page, 84. Just the controlling factor in determining whether the exercise of prerogative power is subject to judicial review. Whether the exercise of prerogative power is subject to judicial review is not its source, but its subject matter. This is the point. Very well put, Malas. It can no longer be said that the prerogative power is ipso facto immune from judicial review. So source doesn't matter, the decision matters. Bottom of that same page, rule of law principle comprises government according to law. The ethos of government according to law requires the prerogative to be exercised in a manner which is consistent with the basic principle of fairness and certainty. Now, let's come to page 85, para 47. Clearly, your lordship has a discretion in the president and the governor for pardons. Nobody disputes that. 200, you have no such discretion except second proviso. But in pardons, look at the judicial review your lordship exercises. Whole scale. The power under 72 and 161, which is the respective powers, is of the widest amplitude and envisages myriad kinds and categories of cases with facts and situations. The exercise of power depends upon the facts and circumstances of each case, and the necessity or justification of exercise of that power has to be judged from case to case. Important to bear in mind that every aspect of exercise of power under 72, as also 161, does not fall in the judicial domain. In certain cases, a particular aspect may not be justiciable. However, even in such cases, there has to exist requisite material on the basis of which the power is exercised, as the case may be. In such circumstances, one cannot draw the guidelines. See the next parameters. Next para. As stated above, exercise or non-exercise of power of pardon by government is not immune from judicial review. Though the circumstances and the criteria to guide exercise of this power may be infinite, one principle is definite and admits of no doubt, namely that the impugned decision must indicate exercise of the power by application of manageable standards, and in such case, courts will not interfere in supervisory jurisdiction. By manageable standards, we mean standards expected in a functioning democracy. A pardon obtained by fraud or granted by mistake or granted for improper reasons would invite judicial review. I think I made an error not underlining that. Lordship may kindly underline that.
It is already emboldened.
It's in our very well. The prerogative power is the flexible power, should be adjudged, etc. Then next page, Willis. In conclusion, it may be stated that there is a clear symmetry between the constitutional rationale for review of statutory and prerogative power. 4 lines later, the exercise of prerogative power cannot be placed in straitjacket formula regarding the extent and amplitude of power bound to vary. When the impugned decision does not indicate any data or manageable standard, decision amounts to derogation. Willis, prerogative was most used for pardon. Because when the pardon power came in 72 and 161, they said it goes back to the royal power to pardon, etc. So that is what is being debunked here. Then, Malas, of course, the be all and say, most famous Malas Keshwanand, just two paras. Justice Sharath and Grover, the Constitution being supreme, all the organs and bodies owe their existence to it. None can claim superiority over the other, and each of them has to function within the 4 corners of constitutional provisions. This I am doing on judicial supremacy. My Lord has become supreme. He has arrogated the power. It is excessive judicial. Those kind of arguments. You are, Malas, implementing the supreme document. Next page. The Constitution has all the essential elements of federal structure, as was the case in the Government of India Act 35. The essence of federalism being the distribution of powers within the Federation of the Union States. All legislatures have plenary powers, but these are controlled by the basic concepts of the Constitution itself. Then I'll skip that, Malas. Just come to judicial supremacy at the bottom of page 88, para 577. This is direct on judicial supremacy. My learned friends, written submissions raises, Malas, I submit the red herring of judicial supremacy. We are unable to see how the power of judicial review makes the judiciary supreme in any sense of the word. This power is of paramount importance in a federal constitution. Well, when Keshwanand has said so, where else do we need to go, Malas? For judicial supremacy, this is the best answer. See the next page, 89. Judicial review is undertaken by the courts not out of any desire to tilt at legislative authority in a crusader spirit, but in discharge of a duty plainly laid upon them by the Constitution. I know judges' names were asked for that. His names. Then, well, at the bottom of that page, there is ample evidence in the Constitution itself to indicate that it creates a system of checks and balances, by reason of which powers are so distributed that none of the 3 organs it sets up can become so predominant so as to disable the others from exercising and discharging powers. Though the Constitution does not lay down the principle of separation in all its rigidity, as is the case, yet it envisages such a separation. The judicial review expressly provided by means of 226 and 32 is one of the features upon which hinges the system of checks and balances. Next page answers the supremacy argument. Page 90. The function of interpretation of a constitution being thus assigned to the judicial power of the state, the question whether the subject of law is within the ambit of one or more powers of the legislature conferred by the Constitution would always be a question of interpretation of the Constitution. Then, well, at page 91, Justice Jagannath Reddy was faced with the argument, political question, no judicial review, less judicial review. He answers it thus, page 91. There is no, in one sense, there is no constitutional matter which in some way or the other does not involve political, social, or economic questions. Otherwise, the Lordship would not be dealing with the Constitution. The Lordship would be dealing with some petty statute. And if the Constitution makers have vested in this court a power of judicial review, and while so vesting, have given it a prominent place, describing it as the heart and soul of the Constitution, we will not be deterred from discharging that duty merely because the validity or otherwise the legislature will affect the political or social policy underlying it. And then the next underlined portion are also important. I am not reading it. Minerva, which was the main judgment, was on the direct point after Keshwananda, page 92. Page 92. But then the question arises as to which authority must decide what are the limits of the power conferred upon each organ, and whether such limits are transgressed or exceeded. So who will do it? Your Lordship will do it. So your Lordship will have to face the charge of being supreme. We are the last one on interpretation. 93, Malas. 93. It is the solemn duty of the judiciary under the Constitution to keep the different organs, such as the executive and the legislative, within the limits of the power conferred. That's another job, Malas, which makes you supreme. You must keep them within the limits. The power of judicial review is conferred on the judiciary under 32 and 226. If I was asked to name, this is a famous Dr. Ambedkar lines, Malas. If I was asked to name any particular article in this constitution as the most important, an article without which this constitution would be a nullity, I could not refer to any article except this one, that's 32, Malas. It's the very soul of the constitution, very heart of it. I'm glad that the House has realized it's important. This is your Lordship's first entry into judicial review. This is your Lordship's first entry into judicial review. High Court's first entry is 226. Together you make up that judicial review, Malas, calculus. And I'll be dealing with my learned friend's 32 argument, which took 1.5 hours, Malas, on the last day when I was to open in the morning. I'll deal with that very briefly.
Whether the state is entitled to.
Yes, yes. Actually, well, I'll show there, the issue is not referred to your Lordships at all. The issue is some other issue. Article 131 is the question the President asked. Article 32 is the question Mr. Mehta is asking. But that apart, I'll deal with why the state can't go. Mr. Mehta has reformulated his own additional question under that question. It's only a 131 question. And in 131, he concedes that the state suing, the state filing against the governor is not an interstate and is not central. He concedes that. And then formulates an additional issue that you can't file a 32, which the President never asked you. I am going to argue the Lordship will refuse to answer that question, but I'll otherwise satisfy my Lords. Next verse, page 93. 93. The judiciary is the interpreter of the Constitution. The judiciary is assigned the delicate task to determine what is the power conferred on each branch of government, whether it is limited, and if so, what are the limits and whether any action of that branch transgresses such limits. It is for the judiciary to uphold the constitutional values and to enforce the constitutional limitations. 94. The power of judicial review is an integral part of our constitutional system. Without it, there will be no government of laws, and the rule of law would become a teasing illusion and a promise of unreality. This is what I comment to your Lordships as we near the end of judicial review shortly. Then, Malas, para 77, page 95. Another argument raised was repeatedly destabilizes the constitutional balance. That's the third line of 77. Well, this is too general. The answer has to be general. My answer is the last 4 lines. If this argument is accepted, that the governor and president would be insulated from judicial review, which would expand the jurisdiction without any limits and is directly antithetical to separation of powers. Then, Malas, para 49 is the political questions, just one judgment, Malas. Just see the last line on page 95, political questions. It's totally irrelevant. It is raised in my learned friend's para 283 of the written submissions, which I mentioned in para 79 of my note. He raises it. And Malas, the answer is the same Keshwananda Bharati paragraph from Justice Jagmohan Reddy, which I've read already, so I'll save time by not reading it again. My Lord has got that at page 96 for us. Same para.
You are again
quoted the same.
Already proved that.
I'm not reading it because that arose in the, this is specifically on political question. I'm not reading it. Minerva Mills, Malas, is next para 82, where it emphasizes that judicial review is part of the basic structure. And then come to 98, which I have not read. Minerva will, after emphasizing judicial review as part of basic structure, come to 98. But merely because a question has a political complexion, that by itself is no ground why the court should shrink from performing its duty under the Constitution if it raises an issue of constitutional determination. This is the short answer in India. All these prerogative political don't arise in India. It's either judicially reviewable, maybe not justiciable in one case. Judicially reviewable, maybe no manageable standards, or judicially reviewable. The controversy before the court may be political in character, but so long as it involves a determination of a constitutional question, the court cannot decline to entertain it. So long as the question is whether an authority under the Constitution has acted within the limits of its power or exceeded it, it can certainly be decided by the court. Indeed, it would be its constitutional obligation to do so. I have said before, and I repeat it again, that the Constitution is suprema lex, the paramount law of the land, and there is no department or branch or government above or beyond it. This is Minerva Mills. Every organ of government, be it the
Yes.
Every organ of the government, be it the executive or the legislature or the judiciary, derives its authority from the Constitution, has to act within its limits. The court is the ultimate interpreter of the Constitution. When there is manifestly unauthorized exercise of power, it is the duty of the court to interfere. And then page 99, the court cannot shirk this responsibility. It's sworn the oath of allegiance to the Constitution. It's also accountable to the people of this country. My lord is not accountable through elections. My lord is not accountable through nominations in that sense. But my lord is accountable in a different way. That is frequently forgotten.
They always criticize that we are not answerable or accountable to anyone.
That's all right. That's your lordship knows the limits, knows parameters. Then was page 100. Separation of powers is there. I'll not read it. Now, Maluds, this very peculiar, strange argument at 101. That, let me summarize the argument. Mere withholding simpliciter and therefore falling through is an interim stage. My lord has frowned upon Quixoto quia timid actions. De facto, we are on this side doing a quia timid action barred by Quixoto. That's the simple summary of page 101, para 86 onwards. Whereas even as I state it, I don't understand how it arises. How two unlinkables are linked by the government. Completely unlinkable. Let me give the answer from para 86. Sir, complete red herring, misleading and one is completely erroneous. Challenge to governor's inactions or actions or withholding of assent are not quia timid actions in the first place. He has alleged it in para 414 of his submissions. Simpliciter or withholding of assent without following the procedure of the first proviso is not a mere interim action, but has serious and far-reaching consequences of final act decision. Mark the word final act decision of intentional inaction and indecision, not envisaged in 200. It's very important. Well, first of all, just pause for 30 seconds. How is your lordship's fellows holding back an assent, keeping in the cupboard a interim action? It kills the bill. It's a complete killing of the bill. And I can't do a so-called quia timid action because of a defection law of Quixoto. Simpliciter withholding, simpliciter withholding of assent is not equivalent to merely leaving the legislative process in media res. This media res is my learned friend's phrase, not mine. This media res I picked up from his submissions. Well, I've read 87. Now I'm on 88. I'm answering him. In 88, he has used the phrase media res. It is not leaving the legislative process in media res. Media res means in limbo. Such simplicity of withholding will amount to a veto of the bill, which was never envisaged by the assembly. I'm in 89. Such unfettered and unchecked power outside judicial review. Then, Malas, Quixoto is only to be stated to be distinguished. Para 90, in very quickly, Malas. Completely irrelevant. Firstly, there is nothing temporary or transient or partial about withholding assent simpliciter. It can be permanent, indefinite. Secondly, it is not in any manner akin to a speaker acting as a tribunal under the anti-defection law, who is acting in the process of taking a final decision. And therefore, in that context, Quixoto held in para 110. Chalk and cheese, Malus, is my last line. Chalk and cheese. Then, Malus, 51 is the 361 argument. Before I read it, Malus, one sentence. 361 protects you from civil, criminal, and tortious action of a personal nature. It does not even touch upon the judicial review of the decision which you have taken, which is open to all challenges. For which decision, certain people, this is not only president and governor, so many people, Wallace, election commissioners, CAGs, Everybody is given that protection that you may take a bona fide wrong decision, court will strike it down. But 361 will not come unless a damages claim. Otherwise, every decision can also have a damages claim. That's all there is. How it is relevant at all to your lordship's argument in judicial review, I don't know. Firstly, the bare text of 361 makes it clear that it is intended only as a protective shield against personal, civil or criminal action. 92. Secondly, the second proviso to 361 itself makes it clear that the validity and legality of all decisions by such constitutional functionaries are liable to be assailed by agreed parties, and that 361 is in no manner intended to preclude the initiation of such legal and constitutional. Otherwise, by 361 you mean you can't challenge a decision of a governor or a president. Just see the proviso, 361. Just for 5 seconds, just see that. It's the second proviso in the first clause in 361. So they give the protection in the opening words and the proviso. Then the second proviso at 361. 361(1). Second proviso. Provided further that nothing in this clause shall be construed as restricting the right of any person to bring appropriate proceedings against the government of India or the government of a state. But I'm developing in more. This is just reading the text. Kindly go further. 93. My page 103, para 93. Constitutional challenges against wrongful actions by the governors or presidents has nothing to do with making them parties personally in proceedings instituted, which is admittedly barred under 361. Otherwise, every decision or writ has a governor's name in the decision, in the name of the governor. Your lordships would go, their actions or inaction would be defended by the relevant government and state authorities. That is by no way inhibited by 361. 94 is the two-line summary. Judicial review merely tests the validity and legality of such actions, nothing to do with personal claims in contract, etc. I now come, to a very important part, the third set of submissions, which is on questions 5 and 7, which is the timelines regarding governor and president. That starts from 104. We have finished judicial review, judicial supremacy, 361, justiciable review.
Your time out.
We'll be, I said so, my timeline and this timeline all be.
You had, your chart shows 4.5 hours. But at 12 o'clock, you'll be finishing your 4.5 hours.
No, my 4.5, I think finishes.
The chart shows 4.5 hours. You started at 12 on the last day. 12 to 1, go to 4.
After your lordship,
3 hours and now
only one person per state.
4.5 hours.
Only one person per state will be within our time, and I'll. This is the.
No, we are only saying.
We have worked it out. We are not.
Time of the other Tamil Nadu council.
You are taking the time of Mr. Wilson and all others.
That your lordship is barred already, Your lordship is barred, Hamlet, without which the Prince of Denmark is being played with. Lordship, we'll work it out. I said, lordship, rest assured. Now, 5 and 7 is the one word is some timelines. Let me read the summary, which are the same. Page 104.
Small page, okay.
Small page 104. Now, let me summarize my submission at the beginning as usual, and then I'll expand. Deletion of a timeline in an earlier draft article and substitution of as soon as possible in the assembly is in no way a fetter or limitation on insertion of time limits to combat contemporary realities and the felt necessities of the time. This is a very important phrase, which imbues your lordship's approach, felt necessities and contemporary realities. Such deletion does not in any manner act as an inhibition or estoppel in respect of judicial stipulation of timelines in the context of repetitively and inordinately delayed disposal of bills by constitutional authorities. This is 102 to 4 is the first one. This also is covered in the same paras. As soon as possible could well have been held in the formative years to be sufficient mainly on the basis that bills pending with constitutional authorities would not lapse upon dissolution of Parliament, of assemblies of Parliament. Comprehensive Supreme Court jurisprudence has emphatically and repeatedly emphasized in diverse cases the imperative urgency in disposal of pending bills and the vital necessity to avoid all delay. These have become only, with greatest respect and humility, sermons without a timeline being specified. They have become this repetitive, emphatic assertion by different judgments of your lordships have become pious hopes, unless your lordship stipulates a timeline. High-powered commissions dealing with the same constitutional issues have repeatedly recommended time limits. That's 109 to 110. Then there is a gap of something which I'll tell Lordship when I come to it. Purposive and theological interpretation. Now, this is a very important part of aid to interpret. Purposive interpretation, what your Lordship calls teleological interpretation. Purposive and, this is wrongly typed, I'm very sorry, not theological, it should be teleological. Anything your Lordship may do, but not do theological interpretation. That phrase came from Benion's very interesting book, made it very, very difficult to read, but an interesting book on interpretation. Kindly correct that, teleological is not only permissible, but vitally necessary to effectuate the true letter and spirit. That's what your Lordship does when you do teleological, where the absence of such an approach would frustrate the entire underlying purpose. Seventh proposition. The judiciary can impregnate the constitution with new meanings, including timelines, in the light of contemporary well-known developments, even if the founding fathers had not envisaged the serious distortion to which a particular provision would be subjected. And last, you can't have completely always a right, a pious hope, and no remedy. So I put it as ibius, ibi remedium. To justify its stand that timeline should not be set under 200 and 201, it is firstly the argument of Union of India that the powers on the said articles are high plenary constitutional functions, and therefore no timelines can be attached. This is one argument, high plenary. I have already dealt with it, about high plenary and prerogative. Secondly, I'm just summarizing his points, in para so-and-so, which I've given there, of the learned solicitor, he argues that the 200 requires the governor to apply his mind independently, quote unquote, in deciding whether or not to assent to a bill. Union of India has submitted that in doing so, the governor has to consider, this is the reason why he needs time, indefinite time, no time limit. It's amazing, with great respect. And Union of India should think of the overall structure of the constitution and the future. Governor has to consider international aspects, security concern, and the political judgment. Then he should fight an election and become the chief minister. This argument of Union of India.
Why can't he consider international aspects, security concerns?
No. He can, consider it within the domain of sending it back once. That he can. He can neither withhold assent, nor kill a bill, nor decide not to do it. And ultimately, most important, as per the question asked, he can't be the judge of this. That is why this structure is a very delicate one, clearly stated in 200. Well, had it been that he can't at all think, they would not have given that first proviso. They gave that escape valve. But that doesn't make him a decider, a judger, a final arbiter, a super chief minister, everything. And ultimately, we are passing unconstitutional bills every day. Supposedly unconstitutional, allegedly unconstitutional. One party thinks is wrong, one party thinks. Whereas in Parliament, there's a debate always that when you're introducing the bill, you can't introduce it because of lack of competence. At the introduction stage, there's a fights all the time. At the end of the day, if he's a majority, he introduces it. Then what happens? Your lordship judges it. That's the meaning of separation of powers. Now, let us come this as soon as possible. There's very interesting material in the debates also, but first let's turn to as soon as possible in para 100. Punjab is a perfectly valid judgment, well considered, and considers this issue directly, Manoj, to a large extent. The interpreted this phrase as an imposition of a constitutional mandate for expedition. Imposition of a constitutional mandate for expedition. Come to the para quoted, these three learned judges. The expression as soon as possible is significant. It conveys a constitutional imperative of expedition. Failure to take a call and keeping a bill duly passed for indeterminate periods is a course of action inconsistent with that expression. Constitutional language is not surplusage. In state of Telangana, this court said, the expression as soon as possible has significant constitutional content and must be borne in mind by constitutional authorities. All these are empty phrases, pious hopes, sermons to be ignored endlessly. The Constitution evidently contains this provision bearing in mind the importance which has been attached to the power of legislation which squarely lies in the domain. Governor cannot be at liberty to keep the bills pending indefinitely without any action whatsoever. You're almost there. The only thing they did not say the time limit. But when you find repetitive inaction, you put a time limit. That's all that happened. Otherwise, he's saying everything about a time limit. Then next with Telangana, 2024. The first proviso to 200 says that the governor may, as soon as possible after the presentation, return the bill if it is not a money bill, together with a message for reconsideration, right? The expression as soon as possible has significant constitutional content and must be borne in mind by constitutional authorities. Now, let's just see the Constituent Assembly. It's interesting. Article 91 in 111 mandated a timeline of 6 weeks. An oversimplistic argument is raised that because your lordship deleted 6 weeks, therefore you can't have a timeline. Just see how wrong it is. But the argument is that your lordship original article had 6 weeks, they dropped 6 weeks, therefore you can't have a timeline. Let's see that. Para 102. Provided that the president may not later than 6 weeks after the presentation to him for a bill of assent, return the bill. 103. The phrase not later than 6 weeks was substituted with as soon as possible. No doubt. Now, Mr. Ahmed had a very interesting objection because he felt that as soon as possible also signifies immediacy. It's too short. His argument was make it longer or give it more time. It's too short. He says they did not leave any breathing time with the governor. Yes, sir, I beg to move in amendment so-and-so for the words possible, the word may be substituted. Read the boldface. If we leave it exactly as Dr. Ambedkar would have, it leaves no margin. As soon as possible means immediately. This was the meaning they understood in the assembly.
One of the members.
Yes. No. This is not. This is accepted by the assembly because as soon as possible is kept back on this reasoning. My lord is right. His understanding.
Yes.
His understanding.
Of one of the members.
Yeah.
Then one of the members recommended that it should be as soon as possible, but not later than 6 weeks.
No.
One of the members also said that it should be as soon as possible, but not later than 6 weeks.
So one was 6 weeks. Now this is a later stage, but give me a minute. 6 weeks was dropped, and the draft which came before Mr. Ahmed had as soon as possible. We are beyond that stage now. Mr. Ahmed is standing on a draft of as soon as possible. Now he stands up and says, as soon as possible is also too fast. 6 weeks is gone. My lord is right. As soon as possible is also too fast, too immediate, he says exactly. Make it little more, play in the joints, margin, he says, for the governor. Accepting that as soon as possible means an immediacy, Dr. Ambedkar and all his supporters retain that. That's the sequence I'm giving. So just read Mr. Ahmed again. As soon as possible means immediately. Possibility, which means physical possibility, is the only test. It may leave no breathing time to the president. The words maybe give him a reasonable latitude. It would mean reasonably practicable. This is the obvious implication. This is the only reason why I have suggested amendment. Now, after this, just for the Honorable Chief Justice's query, there is no real discussion in the CAD except minor things which are not relevant here.
No, there is one of the members suggested
Yes.
that you have the word as soon as
And
possible,
not later.
but not later than 6.
That was earlier. That was the earlier one. My lord is right.
But during the same course.
Yes, the draft came with 6 weeks. The draft came with 6 weeks. When they dropped it to as soon as possible, then this debate of Mr. Ahmed took place. Sequence is, my lord is absolutely right. Original draft had 6 weeks. They then said as soon as possible. Mr. Ahmed says, no, this is also too fast. They retain and stick to it without further discussion, is what I'm saying. Mr. Ahmed canvassed for a reasonable timeline, which was not immediate. He nowhere supported an indefinite time period, as is the stand. This is another second point for us. He nowhere supported another indefinite time period, as the Union of India argues. Mr. Ahmed was only concerned to the extent that he wanted to loosen what he thought was a very strict time limit as soon as possible, which he, Mr. Ahmed, read to connote immediacy. Then
There is
skip.
no number.
I beg your
Nazirul Ahmad used to oppose each and every proposal of Dr. Ambedkar.
lot of. Almost, your lordship is right. Whenever he got a chance to speak, he got
Huh?
Mr. Kamath too. Then let's skip the rest of the paras, come to 108. Now, lordship, we come to 108. At page 110, para 108. That middle quotation, etc., lordship may skip. It's not so. Furthermore, this court has held that where no timeline is fixed, the powers have to be exercised within a reasonable time period. I'll be coming to your lordship doctrine of unoccupied. In fact, the dropping of 6 weeks is the reason why your lordships can operate through judgments in the unoccupied field. Once there is a timeline in the statute, you cannot stipulate judicially. Judiciary can act in the unoccupied interstices where felt necessities require. So the absence of a timeline is what enables your lordships to add that timeline. Now come to Ramchand, 108.1. This is one of the proposition that you must exercise a reasonable time. But can it be said that before the introduction of the aforesaid amendment in the Act, the authorities were at liberty to proceed with the acquisition proceedings, irrespective of any schedule or time frame, and to complete the same as and when they desired? It is settled that in a statute where the exercise of power, no time limit is fixed, it has to be exercised within a time can be held to be reasonable. Now let us come to 11. Ignore para 108, doesn't matter. Come to para 109. Look at all the commissions, fellows. Consistently, one line. The necessity to impose a specific timeline was also identified and suggested by the Sarkaria Commission, which in its report says within 1 month from the date. A recommendation is made by the Punchi Committee, maximum 6 months after the bill is presented. Then comes, your lordships, in 110, the National Commission, which is so-called Venkat Chalaya Commission. This is the Venkat Chalaya Commission. They say, period of 4 months, about they divide it, assent. Then other things are said, delete the words, withhold assent, etc., etc. Just see F, what they say. F is very interesting. The Venkat Chalaya Commission, of course, it's a historical fact. In the alternative, the Venkat Chalaya Commission, not me, it may be more advisable to delete altogether the words of Article 200 empowering the governor to reserve a bill for the consideration of precedent, except in the case contemplated by the second proviso to 200 and the cases where the Constitution requires him to do so. Such a course would not only strengthen the federal principle, but would also do away with the anomalous situation wherein a bill passed by the state legislature can be killed by the Union Council of Ministers, advising the president to withhold his assent or just cold storage. He goes very far. This is a facet I'm giving us. Now let's come to 113. So 3 commissions I've given levels. In order to, I'm on para 113. In order to interpret as soon as possible, the union seeks to place reliance on a selective extract from Abdullah Kuni, which refers to Francis Coralie Mullin. Well, I am now quoting the relevant part of another paragraph of this judgment, which is, I believe, Malas, a constitution bench. This KM Abdullah is a constitution bench, CB. So these things should have been written by us. We have not written it there. It's a constitution
The
bench.
executive powers, Dr. Singh,
I-
not a constitutional. Basically administrative law principle, not constitutional law principle.
No, I'm saying it's a constitution bench. I'm only saying it's a constitution bench, Malas. I am not disputing as soon as possible will be my lordship's interpretation.
Administrative,
Yes. Well, sometimes those two are intertwined very, very broadly.
sometimes.
Frequently, the magnum opuses on that topic deal with both worlds,
The larger
Constitutional administrative law. but they can be separated, no problem. Article 5 of 22 therefore casts a legal obligation on the government to consider the representation as early as possible. It's a constitutional mandate commanding the concerned authority to whom the detainee submits his representation to consider the representation and dispose of as expeditiously as possible. The words "as soon as may be" occurring in 22(5) reflects the concern. I'm only giving analogies, Manas, analogies. Reflects the concern of the framers that the representation should be expeditiously considered and disposed of with a sense of urgency without an avoidable delay. However, there can be no hard and fast rule dependent on the facts. Now, Manas, this is cited against me, this judgment. This is cited against me. See the next boldface. The requirement, however, is that there should not be supine indifference, slackless or callous attitude in considering. Any unexplained delay in the disposal of representative with a breach of constitutional imperative would render the continued detention impermissible and illegal. Now, Malus, Kesham, my lord is aware of.
On a preventive detention.
I agree with you. Because they were interpreting as soon as possible, so I've just given that citation. Then Malus 117 is Manipur. I think your lordship is well aware of that. That is also a case where there is no timeline in the 10th schedule. The speaker is a high constitutional authority. He is not, of course, he is not acting as a governor is. I know that. He is a persona designata. High constitutional authority.
But there he is acting as
As a,
tribunal.
as a tribunal. Correct, correct.
Tribunal.
But no time is specified. So your lordship specified 3 months. I'm only on that. I mean, it's not that, Manus, where the
Keshav,
felt necessities.
3 months in the facts of the said case.
I beg your pardon. Yes. That your lordship will decide. It's not that I'm saying, Manus, that in fact, where there is nothing occupying the field directly, and your lordship finds contemporary realities and felt necessities so require, then it is all the more easier and frequently done by your lordship. There is no constitutional bar to doing this.